The Supreme Court allows gerrymandering in Texas in a 6-3 opinion. What does that mean for redistricting across the country? In Abbott versus League of United Latin American Citizens, the trial court preliminarily found that Texas's new congressional maps were impermissibly drawn for racial reasons and prohibited the use of those maps because you can't do that. The Supreme Court majority reversed and provided 2 reasons. First, the trial court didn't look at the evidence the right way. And second, the side opposing the map was apparently supposed to provide an alternative map in order to win. The federal government has been trying to get states to redistrict congressional seats to send more Republicans to Congress. In July 2025, Texas officials received a letter from the Civil Rights Division of the Department of Justice. Assistant Attorney General Harmeet Dillon, who is in charge of that division, wrote to Texas Governor Greg Abbott and Texas Attorney General Ken Paxton, claiming that several Texas congressional districts needed to be drawn again to change their racial makeup, which is ironic because that's exactly what conservatives of government are claiming cannot be done. The letter cited cases but didn't make much sense, and you don't have to just take my word for it. Texas Attorney General Ken Paxton wrote back to the Department of Justice just a few days later, saying the exact same thing, while also affirming his commitment to supporting President Trump and ending race-based practices. However, Texas Governor Greg Abbott sure did get the memo, and he called a special legislative session to redraw congressional maps based on the Department of Justice's concerns. So is race-based based again? Justice Kagan's detailed dissent points out that the law prohibits drawing congressional districts along racial lines without a compelling reason. And Texas didn't even try to argue that it had a compelling reason. Instead, Texas argued that it never considered race, despite the Department of Justice's letter telling Texas to consider race, and despite the redistricting process beginning in response to that same DOJ letter. The dissent argues that the trial court's determination, made after spending quite a bit of time considering the evidence, shouldn't be overturned by an appellate court, especially when there appears to be direct evidence of racial gerrymandering. The dissent also argues that an alternative map is not required in a case like this one when there is so much direct evidence of racial gerrymandering. But the dissent also points out something very important about the timing of all of this, with the majority noting that the 2026 campaign is already underway. If a state wanted to do something that was blatantly unconstitutional, it could delay its action until the last minute, reduce the amount of time that citizens have to challenge the government's actions, and then get away with its unconstitutional actions because the court simply doesn't have enough time to do anything. We've seen that happen multiple times right here in Missouri, with the state opposing the people's power to put issues on the ballot time and time again. As the dissent writes, that cannot be the law, except, of course, that today it is. So what do you think? Is this more big government gone wild? Is racial gerrymandering back in? Let us know what you think about this decision in the comments.